afternoon we will hear an oral arguments, I should say, in case number 29046. It is entitled The State of Ohio versus William Lewis. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you would like to reserve time for rebuttal, just let the court know at the start of the argument, and I'll keep you apprised of the time as we move along. The arguments are being recorded and will be posted on the court's YouTube channel, so I ask counsel to please remain at the podium and keep your voices up. Now, the court has read the briefs in this matter, so we are prepared to proceed when you are.
Good morning, good afternoon, Your Honors. Brian Bremer on behalf of the state of Ohio. I'd like to reserve 5 minutes for rebuttal.
Thank you.
This matter is before you today on the state's appeal as of right from the trial court's granting of defendant Mr. Lewis's motion to suppress. The trial court incorrectly found that Trooper Sharapa did not have probable cause to arrest Mr. Lewis for operating a vehicle while intoxicated on the day in question. It is important to note at the very beginning here that probable cause is not a high burden for us to meet. The question is under the totality of the circumstances, whether a person of reason would believe that a crime has occurred. It's far less than reasonable doubt. It's not even more likely than not. It just has to be a likelihood of a crime having occurred. In this case, and it's a factual inquiry, so in this case, Trooper Sharapa observed Mr. Lewis driving down the road in his vehicle. He was missing his front license plate, and his windows had a very dark tint to them. Trooper Sharapa pulled Mr. Lewis over to investigate those issues, and when he approached the vehicle, he detected a strong odor of alcohol emanating from inside. He spoke with Mr. Lewis. Mr. Lewis had slurred speech. Trooper Sharapa saw that he had bloodshot and watery eyes. Trooper Sharapa also noticed that Mr. Lewis had difficulty retrieving his driver's license and registration when it was requested from him. Trooper Sharapa also asked if Mr. Lewis had been drinking, and Mr. Lewis admitted that he had had 2 drinks before getting in the car. At that point, Trooper Sharapa asked Mr. Lewis to exit the vehicle, and he performed field sobriety tests, which are obviously the horizontal gaze and stagnance test, the walk and turn test, and the one-leg stand. As a result of those tests, Mr. Lewis showed 6 signs of intoxication from the HGN, 5 signs of intoxication from the walk and turn, and 3 signs of intoxication from the one-leg stand. Trooper Sharapa then asked Mr. Lewis if he'd be willing to submit to a breathalyzer test at the scene. They have a portable breathalyzer test in their vehicles with state troopers, and Mr. Lewis declined. At that point, Trooper Sharapa placed Mr. Lewis under arrest. Based on the totality of the circumstances known to the officer at the time of the arrest, there was probable cause to believe Mr. Lewis was intoxicated at the time he was operating his vehicle. Some of the dispute in this case turns on the field sobriety tests, but even if you don't consider those, the trooper had probable cause. Mr. Lewis's eyes were bloodshot and watery. He had slurred speech. He fumbled for his driver's license. He admitted to having 2 drinks, and when offered the opportunity to exonerate himself with a breathalyzer test, he refused. All of those are indicia of his intoxication at the time. But then beyond that, the trooper also had the field sobriety tests. And those tests, if they're administered in substantial compliance with the NHTSA guidelines, tend to show an individual is above the legal limit of 0.08 if they have a certain number of indicia, which Mr. Lewis had in this case. And for those reasons, the trooper very clearly had probable cause. This isn't a close call in many respects. It's actually overwhelming evidence of Mr. Lewis's intoxication.
Does the plausibility of the defendant's explanations for what the officer observed factor into his conclusions, his determination of reasonableness and criminal activity?
They do. I think you're referring to the Wesley case from the Supreme Court this last year, in which the Supreme Court reiterated that an officer need not completely eliminate the innocent explanations offered by a defendant, but they need to consider the plausibility of their explanations as part of the totality of the circumstance analysis.
Did that occur in this case?
It did, because I guess I would say that I believe that the court, to the extent it was giving weight to Mr. Lewis's medical conditions, was actually going beyond giving a plausible explanation. It was actually going beyond the trooper's actual knowledge at the time. In this case, there's no evidence really to support a lot of the statements made in Mr. Lewis's brief about what his eye conditions cause as far as the watery eyes. And there's no, and he talks about a hernia surgery that would have maybe affected the walk and turn test and the one leg stand test. But in both of those, there's no evidence that there actually was a hernia surgery in the record. That came out of a cross-examination question by defense, Mr. Lewis's attorney, but that's not evidence. And the trooper answered that no, Mr. Lewis never said that he had a hernia surgery. So there's no basis to conclude that he actually had.
So no medical records, no testimony from a doctor, no prescriptions entered into evidence?
Correct. There was a medical waiver form that was in the car at the time that described Mr. Lewis as having photophobia, and I apologize, I don't know the name of his other condition, but the medical waiver note said that please excuse the tinted windows. Basically, the medical waiver was for the tinted windows of the vehicle, not for, did not say please excuse his watery eyes. It's not a sign of intoxication. It is a sign of this condition. It did not say that. It just went to the window tint, which is, as the court in this case remarked, that was probably why the trooper never charged him with the window tint violation.
And where would you see in the record what
the trial court, during the course of the proceedings, made remarks from the bench, and this was mostly after that remark specifically about the idea of the medical waiver, that was made after the state addressed its presentation, I believe. It was, and that was when the court remarked that that was probably why the trooper didn't actually cite him for the window tint.
And the reason I'm asking is the journal entry simply states, the reasons set forth on the record, the court grants the motion to suppress. And where are the reasons that were set forth on the record?
To that point, after the trial court, after the state finished presenting its case, the trial court made some comments on the record about where it walked through some of the evidence, and it did not really go into in-depth analysis about why it was finding that there was no probable cause. It just said the best we can determine from the way the court was discussing, he took issue with the fact that during the field sobriety test, the trooper moved Mr. Lewis to the right of the video when he did the HGN, and then he performed the walk and turn test and the one leg stand close to the front of the vehicle, so that the court remarked that he was unable to see the feet during the test. And that doesn't really go to whether or not he substantially complied with the trooper could substantially comply with the test. It was almost an additional burden that the court was trying to impose upon the trooper for how to do the test, where if you have a video, you should do it in a way that the court can then evaluate the test. That was the implication.
So did the court make any actual factual findings in this case?
The court did not, I don't believe the court actually laid out factual findings. It was not equivalent to some of the other cases where the court has actually gone through and said, I find that the trooper to be credible or not credible. The court never made a finding along those lines about what evidence it was saying was correct and what evidence was not. It was, for the most part, the court just said that at the end, reviewed, said it was taken into consideration the testimony presented, and then found that that there was not probable cause that Mr. Lewis was intoxicated. But the fact of the matter is, in this case, there's really no competent, credible evidence contradicting the testimony of the trooper at any point. The video doesn't contradict the testimony of the trooper. One of the issues that was raised by the defense counsel on appeal here was the idea that Mr. Lewis had the HGN performed where flashing lights were in his eyes. But if you watch the video, Mr. Lewis moved out of frame in such a way where you can actually see the other bruiser that he's referring to having the flashing lights still going. Mr. Lewis was out of frame, and in order for that to be his peripheral vision, he would have had to be in frame most likely. And then also, when questioned about that, the trooper said, "I do not believe the flashing lights had any effect on Mr. Lewis's HGM results." And he is trained in how to perform those tests, and he'd be trained to spot if there was an external factor like that, he would have been trained to note that. But the evidence in the record would indicate that Mr. Lewis was not within, did not have that in his peripheral vision at the time. And there's no evidence that suggests that he actually did. Mr. Lewis never testified, which he wasn't required to, obviously, but there's no testimony other than the trooper in this case about what happened. And there's another issue that was raised about Mr. Lewis performing the walk and turn test in sandals.
And you're at 5 minutes and 18 seconds, just so you know.
I'll be quick here. The walk and turn test with the sandals on, and he said, well, the trooper never informed me that I did not need to, that I could take it without, perform the test without the sandals. Which, to the extent that's true, and even assuming that was an issue, Mr. Lewis stopped during the middle of the test, asked, "May I remove my sandals?" The trooper said, "Yes, you may." And then the trooper testified that he only considered the results of the test from when Mr. Lewis performed it without sandals on. And that is, so really there's no evidence in the record that the trooper did not substantially comply with the NHTSA guidelines. And I will reserve the remainder of my time.
4 minutes and 36 seconds.
Thank you.
Actually, you'll have 15 minutes.
Good afternoon, Nicholas Cardinal for defendant William Lewis. This is arising out of an OVI arrest back in March of 2018. I would like to emphasize for the court before I begin that the defendant was victorious on his motion to suppress, and that we would emphasize the trial court's discretion in viewing the facts, evidence, and testimony at the suppression hearing and throughout the case. The burden is on the state to prove that the trial court ruled incorrectly. Many of the state's arguments go towards what probable cause is, was, and didn't exist at the time that the officer made the arrest. My client's position and our position the entire time was that many of the indicia of intoxication were due to medical conditions that were made known to the officer at the time of the arrest repeatedly and negatively affected the standard field sobriety tests, or SFTs. The state noted that the flashing, so the trooper pulled over my client and another trooper came, and the second trooper's lights were on during the submission of all the SFTs and the entire arrest. The state claims that those lights were not in my client's vision, nor would have affected my client's vision, but my client stated during the arrest, and it is in the record, that the flashing lights were negatively affecting his eyes. The reason for my client's window tint, as noted, were due to the eye conditions on his medical card, which he had in the car.
Counsel, why the window tint? Of course, it's kind of not an issue, at least in the sense that he wasn't charged. It was an issue for probable cause. But how is anyone to know what's true or what isn't true? I guess what I'm saying is, if I'm stopped by a police officer and I'm asked to perform the test, and I say, I know I have this condition, I have a broken toe, I broke my left foot twice, I have this and that. So the police officer then should not attempt any tests if I seem to be standing there doing fine. I guess what I'm saying is that an issue of fact for a finder of fact or jury to determine whether in fact any of that is true or any of that affected my ability?
Well, Your Honor, it's not our position that any medical condition would disallow an officer to perform the test. In fact, during the stop, my client made it clear that he has very sensitive eyes, and that the flashing lights were affecting his eyes, he told the officer that, and the officer refused to turn his lights off, or at least did not turn the lights off. In your example, if he had a broken toe and the officer then said, well, okay, we won't do the walk and turn test, there are other tests you can take that won't affect your legs, I think that would be more in line with what happened here. Obviously, it's a reasonable and prudent person standard in terms of probable cause. A reasonable, prudent person, upon hearing multiple times that my eyes are sensitive to light, specifically to flashing lights, why would the lights still remain on? And majority of the indicias of intoxication came from the nystagmus tests and the Romberg test, which are basically eye tests. So the defendant's position is that the officer, although noted that he did have blurry eyes, again, that goes to his medical condition, which was made known to the officer at the time of his arrest. Although my client did admit to having 2 drinks before he got in the car, it's in our brief that consuming small amounts of alcohol is not illegal, it's actually being impaired while driving. Therefore, it's our position that the fact that he admitted to having 2 drinks doesn't necessarily mean that he is intoxicated.
Unless they're both long out of stage.
Pardon?
The 2 drinks is, you're saying 2 small drinks, but we don't even have those stacks for receivers.
I believe in the record he said they were 2 twisted teas. That's what we have. But it's our position that alone is not enough. Also, his difficulty finding the license, I know there is case law saying that could be used in terms of indicating probable cause, but I don't think anybody here could say if you get pulled over by a police officer, you're nervous, and fumbling for your license doesn't necessarily mean that you're intoxicated.
Counsel, do we know whether the judge even considered his fumbling for his license?
We do not know. The record was rather unclear.
Is that a problem? I noticed one thing that your opponent said was the best we can determine. I guess what I'm saying is, were there any findings? Not comments, but findings.
There were not. The journal entry from the trial court was rather short.
And what about in the record?
In the record, in the transcript of the proceedings, most of the questioning and examination came upon the administration of the SFFTs, not necessarily the odor of alcohol or fumbling of the license. That was put in the record. I did cross-examine the officer and said, well, is it your experience that people are nervous when they pull you over? And I think everybody knows people are. Obviously, that's one of the factors, and we would argue that under the totality of the circumstances, probable cause did not exist.
I think what Judge Callahan is asking, though, is when we look at that transcript, are we going to see findings from the judge? The court finds that the prescription that Mr. Lewis was taking resulted in him having watery eyes, or was the reason for him dropping his license, or was the reason for... Did the court make those findings in the record? Not necessarily in the entry, but did he make any findings on the record at the conclusion of the hearing?
Not to my knowledge, Your Honor, no.
And her follow-up question was, does that matter?
In our opinion, we would like to take we're taking the view that the trial court was the best trier of fact and was there and heard the testimony in person from the officer. Whether or not the judge decided to list all of his or her reasons on the record should not matter from my client's point of view.
Wouldn't it matter from our perspective when our job is to look what the trial court decided and determine whether they were correct? This is motion suppressed. That's our standard of review.
Well, Your Honor, I'm not going to sit here and say that the trial court didn't do anybody any favors by having a vague opinion and did not note anything within the transcript proceedings on the records. It certainly would have been a lot more helpful for the state, I'm sure, and it would have been more helpful for me in defending this. All I can go by is what happened at the hearing and what's in the transcript. Other than the medical part, what other evidence was there to
for the officer to consider in considering the explanation that the defendant gave.
Well, the officer did ask my client whether he was on any prescription medications, and he did indicate to the officer at the stop he was on prednisone. So the officer did know that. He did have the card, and it was my client's statements made during the stop that he had an eye condition that really affected his eyes and would affect the performance. He also did state that he had hernia issues during the arrest. No medical evidence or records were introduced prior to the hearing to substantiate that, but that was all made known to the officer at the time of the arrest and would have gone into his decision-making process as to whether or not there was probable cause. I would like to reserve whatever remaining time I have for a while.
Well, you're not really counting on this, so.
Oh, no.
You will get
Sir,
the voting.
okay. All right. Well, how much time do I have left, Your Honor?
You got 5 minutes and 38 seconds.
Okay, thank you, Your Honor.
Use it or not use it?
Let me take up some of your time with a question.
Okay.
I want to throw out all the field sobriety tests. Everyone. Oh, sorry. I'm going to throw out all the field sobriety tests right now for purposes of just this question. If I read the briefs correctly, the officer would have testified there was odor of alcohol, not just from in the car, but from when your client got out of the car. The fumble for the license, dropped his license, red, bloodshot, glassy eyes, and he refused to take the breathalyzer test. Under current law, is that the totality of those items sufficient for probable cause to arrest for OVI, even if you get rid of those field sobriety tests?
Our position is that it's not, simply because you could take out the blurry eyes because the medical condition was made known to the officer. And
What was it about the medical condition that caused red, bloodshot eyes?
sensitivity to light.
Tinted windows.
Tinted windows were the reason the car was in the car to allow the tinted windows.
Wouldn't the tinted windows prevent him from having red bloodshot watery eyes? That's what the purpose of the tinted windows is, isn't it?
Well, when he's in the vehicle, but once he's out, our position is no. I would just like to close by saying that the trial court was the best viewer of the evidence in this case. They ruled in our favor, and we would move to have the appeal dismissed and the trial court's decision sustained. Thank you.
Thank you. Then the appellant has 4 minutes and 36 seconds.
Thank you, Your Honor. To address an issue that's been asked a couple of times, the trial court at the end conclusion of the trial said, for the hearing, said that he had an opportunity to review the dash cam footage and the interaction between the defendant and the officer, and he found that there was no probable cause. Those are the findings of fact that are directly stated on the record in this case. The other thing I want to address that defense counsel brought up is Mr. Lewis did say that the flashing lights were watering his eyes. He said that, however, when he was on the hood of the car, of the trooper's car, looking at the other car that had its lights on. The trooper then moved him out of frame to perform the HGN test. The testimony about lights flashing in his eyes was when he was looking at the lights. It wasn't during the HGN test, which happened off to the side and out of frame and out of the view of the actual lights.
Before you go on, quick question. Is the dash cam video part of the record in this case?
It is, Your Honor.
It's okay, thank you.
The other issue that I also want to point out that Trooper Strapa testified that he observed the bloodshot eyes in the vehicle when Mr. Lewis was actually still in his car. There's also an issue of so a lot of his cases trying to be turned on these medical conditions that no police law enforcement officer who hasn't been to medical school would even have a chance of knowing this information at the time. Like the idea that there's a even assuming that it's true that his condition would have watery eyes, would cause watery eyes, that doesn't mean that the watery eyes that he's exhibiting at the time were a symptom of his underlying condition, as opposed to being a symptom of his alcohol consumption. And in this case, they're being asked to make a judgment call about which one it could possibly have been, but absent a medical testimony of someone who's examined him, we wouldn't have any way to know that his eyes water constantly under this condition, or is it just under certain circumstances? And it doesn't mean that the fact that he had watery eyes here was not an indicia of him drinking. And to answer your question, Judge Schaefer, it was with Twisted Tea. I'm not familiar with that drink, so I don't know how much. It was not Long Island iced tea, to the best of my knowledge. And I believe that this, the analysis of probable cause is an objective standard. However, it still needs to be information that's available to the police officer at the time. And the idea, and this is something you raised, Judge Callahan, about the idea of what the officer could or could not know at the time of the stop, what the side effects of this prescription drug, there's no way to impute that information to the police officer at the time. And the same thing with these medical conditions that they have. That's evidence that you bring out at trial to try to establish that I was not intoxicated at the time. But that would be ways you argue to a jury in a medical testimony about the fact that no, these are not signs of intoxication. These are signs of my medical condition. These are signs of my prescription drugs, and that's where you try to demonstrate that it's not beyond a reasonable doubt that I was intoxicated. But again, the standard here is much lower. It is not reasonable doubt. It's not more likely than not. It's just a likelihood that he was intoxicated. And under the circumstances here, there's significant evidence that he was. And I think that one of the more probative aspects of this entire case in many respects is he refused to take a breathalyzer test at the scene. And he refused, unlike a lot of cases, he refused before he was arrested. And this court and other courts have held that is probative evidence of an individual being intoxicated. It's not dispositive, but it's probative. And when you look at the fact that he had 2 drinks, which if you read transcripts on a regular basis, everyone has only had 1 or 2 drinks. No one has ever had 4 or 8. But so the officer, once you get the admission of drinking, the officer has to weigh that against his 6 years of experience of how many drinks do these people typically say they have? Well, it's always 1 or 2. And when you consider, so he has the admission of drinking, bloodshot eyes, watery eyes, slurred speech, he's fumbling, dropping his license in the car. There's a strong odor of alcohol when he approaches the vehicle. It's not just a moderate odor, it's not a slight odor, it's a strong odor. And then he refuses the breathalyzer test.
Your time is up.
Thank you, Your Honor.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement and issue a decision in due course. Of course, the clerk of courts will mail a copy of the decision to both of you the day it is released. The opinions are also posted on the Supreme Court of Ohio's website, so you may check there as well. Before we take questions,